Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we are going to talk about a patent owner, patent holder, and a generic drug manufacturer. So let's get into it. In the early 2000s, the patent holder and the generic drug manufacturer get into a dispute. In 2007, they settle that dispute using a settlement agreement. Now, one of the terms of that settlement agreement is that the patent holder will grant a license to the generic drug manufacturer to use the patent without paying any royalties 2 weeks before the patent expires. Does that make sense? So when the patent expires, everyone can use it, but what the patent holder is doing to settle that earlier piece of litigation is to say, we'll give you an extra 2 weeks. We'll let you in another 14 days early, and that's going to give our generic drug manufacturer a bit of a head start to getting those generic drugs onto the market and pursuing those commercial interests. So that happens, that agreement is 2007. And there are a number of dates contemplated in that agreement because there can be a bit of an argument as to when the patent's going to lapse. Are there going to be extensions applied for? But as it turns out, the patent lapses on 13 June 2009. Right? Now, let's keep the timeline ticking over. In June 2014, the relevant body for dealing with patent extensions grants an extension to the patent. And the patent is extended till a date in December 2012. And so there is a dispute because what the patent holder says is, pursuant to the relevant section of the Patents Act, I am allowed to sue for any infringement from the date my patent lapsed, 13 June 2009, to the date it was extended to, which is the late 2012 date. Now, I hope that makes sense to you. So let's just go over it one more time. Patent holder, the patent lapses on 13 June 2009. Later, the patent holder applies for an extension, and in 2014, an extension is granted to a date in 2012. Right? So our patent holder gets an extra 2.5 years of holding the patent. Now let's refresh our memories on what the parties agreed in 2007. Because you remember in 2007, they had an argument and they settled it pursuant to this settlement agreement. And one of the terms of the settlement agreement was that the generic drug manufacturer would get the 2 weeks early access, would get an irrevocable, royalty-free license 2 weeks before the expiry of the patent. And so the question arises, because remember, the patent lapsed on 13 June 2009. It's lapsed. Later, there's an application to extend it, and the effect of that application is it gets extended from June 2009 to December 2012. But you can't apply for an extension of that kind unless it has indeed lapsed, and so it's lapsed. And so it is certain that 2 weeks before 13 June 2009, what's that, 31 May 2009, our generic drug manufacturer has a license. And the question that comes before the court is this license a 2-week slice between that 13 June 2009 date, where the generic drug manufacturer gets to use the license 2 weeks before that, and the 2 weeks ends because the patent holder later got an extension? Does that make sense? Because remember, it lapsed on 2009, then into the future, on our timeline, the patent holder got an extension that extended it from that 13 June 2009 date. So the question is, in that 2007 settlement agreement, is it that all the generic drug manufacturer got was this 2-week sliver, or did it get from this 2-week period on into the future? At first instance, what the judge said was yes to that first question. It is merely the 2-week sliver because the patent lapsed on that date, which meant that there was the commencement of the 2-week license, and then subsequent to that date, the extension applied. Right? Does that make sense? That extension gives the patent holder the right to sue for infringement for this period. On appeal, in short, what the court says is no. What the court says is that would work a commercial nonsense, bearing in mind the broader context of the agreement. So in 2007, the likelihood of the extension to the parties' minds in 2007 was so remote that they probably would not have borne it in mind, and on the proper construction, the proper interpretation of the contract, what was intended was that the generic drug manufacturer holds an irrevocable royalty-free license from 2 weeks before the date of that lapse, continuing into the future, because to do otherwise, which is to grant a funny little 2-week sliver where the generic drug manufacturer can sell drugs before they're shut down again, would work a commercial nonsense and would not be consistent with the tenor and the content of what the parties had agreed in 2007. And so what we learn is, despite the apparent appropriateness of it being merely a 2-week sliver, as it appeared with respect to the primary judge, the court found on appeal, the full court of the federal court, found that the appropriate interpretation of the contract was that in order to avoid working a commercial nonsense, the grant of the license commenced from 31 May, whatever that date is, 2009, and continuing, meaning the patent holder was not able to sue for damages from 13 June 2009 through to that December 2012 date. A little bit of time travel, a little bit of patent administration excitement, and hopefully a little bit of value there as well. I look forward to joining you again soon for another coffee and another case note. Cheers.